Important breaking news. The Wall Street Journal editorial page has just come out with an editorial that is urging, that's right, urging the United States Supreme Court to take the Snope case dealing with Maryland's ban on semi-automatic rifles such as the AR-15. This is very good news because the Wall Street Journal editorial page is the sort of thing that the Supreme Court justices themselves actually read and pay attention to. And given the fact that later this week the Supreme Court is going to conference the Snope case for the first time, this is a big deal. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a nominee for the 2025 Gundies Awards in Las Vegas at the end of January in the category of Top Voices of the 2A, the Second Amendment. If you're going to be voting for the Gundies, you can vote every day through now through the end of the month. Make sure you vote for Mark Smith, Four Boxes Diner, for the Top Voices of the Second Amendment for the 2025 Gundies Awards. We've been a finalist in a lot of categories. We've been nominated in a lot of categories. We haven't punched through in one. This is the year I think we're going to do it. Fingers crossed and candles lit. All right, folks, so here's the story. It is very important, in my view, that the center of America, or people that are viewed as more center-right, support the notion that we all have the right, which we do, to keep and possess AR-15 semi-automatic rifles. This should be a very easy fight because of the 2008 Supreme Court decision of District of Columbia versus Heller that said that if an arm or a category of arms are in common use by Americans for lawful purposes, they cannot be banned. They are protected, period, full stop. And it doesn't matter why they're in common use at all, as long as they're commonly used by Americans for lawful purposes. In the Heller case, it was the D.C. ban on handguns that was struck down because handguns, for whatever the reason, were viewed as commonly owned by Americans for lawful purposes. Now, as you know, we are fighting tooth and nail in the blue state courts, and it's in the blue state courts only, because as you know, the red states in America do not enact gun bans. They're not banning AR-15s. They're not banning semi-automatic weapons, semi-automatic rifles. As a consequence, the only courts where AR-15 bans, semi-automatic rifle bans are percolating up and being decided are mostly in states that are deep blue, anti-gun, anti-American, anti-American values, anti-heritage American places, by and large. Most of these are controlled or dominated by urban elite cities, whether it be Chicago dominating Illinois, New York City and Albany dominating New York State, San Francisco and Los Angeles dominating California, Baltimore dominating Maryland, Boston dominating Massachusetts, and so on and so on. You get the point. So it's very important when a well-respected news organization, which is still the Wall Street Journal, in particular the editorial page, based in New York City, mind you, not known for being radicals in any respect. These are mainstream, establishment, conservative, Republican, Reagan Republican types, where they enjoy MAGA. They like MAGA to some degree, but trust me, they're a lot more centrist than a lot of people on the Make America Great Again movement, if you want to draw it on the spectrum. Keep in mind that Peggy Noonan still writes for the Wall Street Journal, and if you know what I'm talking about, you really know what I'm talking about. So with that backdrop, it's extremely important that the Wall Street Journal has just come out with a powerful editorial by its editorial board urging the Supreme Court to grant cert, which means to hear the case on the merits, the Snope versus Brown case out of the Fourth Circuit Court of Appeals. This is what the start of this editorial article by the Wall Street Journal says. AR-15 rifles and the Constitution. Does the Second Amendment include the right to own one? The Supreme Court might soon decide. The Supreme Court has heard 2 major Second Amendment cases in 3 years, but no rest for the weary. This month, the justices are expected to consider whether to take Snope versus Brown, an appeal challenging a Maryland law that bans the sale and possession of assault weapons, quote unquote. That includes the AR-15 style rifle, sometimes called America's most popular rifle. So that's how the Wall Street opened up. And of course, they go on to explain the issues presented. For a lot of people who read the Wall Street Journal, they're Wall Street bankers, they're New Yorkers. They don't have experience with firearms like a lot of other Americans. And I've often said this since I've been in New York City for a long time. The reality is there's a lot of conservatives in New York City that are sort of agnostic on the gun question because they've never even had an opportunity to touch one. And if you haven't even had an opportunity to touch one, and it's illegal for you to touch one in New York without a license, why would you get a license to do something you don't even know if you like because you've never even touched one? And that is an ongoing problem with a lot of urban elites all across the United States, even urban elites who lean to the right, who are conservatives, that tend to vote for Reaganomics and the like. With that said, this is what the Wall Street Journal does to kind of explain the issue to its readers. The Fourth Circuit Appeals Court upheld this law this summer in a 10-5 en banc ruling. Guns such as the AR-15, Judge J. Harvey Wilkinson III writes in that opinion, fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. Judge Wilkinson said Maryland's law fits comfortably within our nation's tradition of firearms regulation as a state regulation of excessively dangerous weapons. Now, of course, when this decision came out and Judge Wilkinson, who is absolutely terrible, 1,000% terrible on gun-related issues, he clearly is a genius in his own mind. Now, it was true many years ago that Judge Wilkinson was an important conservative jurist that would actually feed people to the United States Supreme Court in terms of law clerks. We can talk about that in a separate video. But he was important. His time has passed him by, and he should have been off the bench long ago, and he clearly is terrible on guns and terrible on the Second Amendment. And if you listen to his questions, it's pretty clear he speaks from the heart and not from his brain. He doesn't know anything about guns, and if you listen to his discussion of how machine guns cut bodies in half, you realize that when it comes to firearms and gun law, he is not a Sharpie-Parpy. That is just the harsh reality of it. Nevertheless, he did write the opinion, and it's nice to see that the Wall Street Journal specifically mentioned that. The reason why it's good that they mentioned that, because then the Wall Street Journal goes on to basically say, well, Judge Wilkinson may not be the best on this issue, may not know what he's talking about. And the reason why I think it was good the Wall Street Journal did this compare and contrast is they go on to say, look, the Supreme Court in Heller and Bruin talks about something that's in common use by Americans for lawful purposes. This is often discussed. This is kind of the standard. They go on to say that no matter how you look at it, there's tons of surveys and lots of information that lots and lots of people own these AR-15 semi-automatic rifles. In fact, they are indeed the most popular rifle in America, which is 100% true. No one disputes that. In fact, I believe even ATF has repeatedly said this, as well as, believe it or not, the dissent, as you recall from my videos, of Justice Sotomayor in the Cargill case dealing with bump stocks. In her dissent, she literally admits that semi-automatic rifles like the AR-15s are super duper popular. So there's no dispute that these basic AR-15s that shoot 223 rounds or 5.56 rounds are ubiquitous. Everyone has those, and the only reason why people don't have these is they're probably in terrible states where they're banned from having them. Otherwise, they would go out and buy them too, and our numbers would be even higher. So after recounting the information about how ubiquitous AR-15s and semi-automatic rifles are, the Wall Street Journal does again point out some other observations from Judge Wilkinson, really saying that Judge Wilkinson thinks he knows best. Again, it's not up to the government to tell us what's best for us. We're supposed to make those decisions because at the end of the day, we the people rule, not they the judges or they the legislatures. That's how our system is set up. And that's what the Wall Street basically points out here. The Wall Street Journal points out here when they quote, again, Judge Wilkinson saying, I know best and you Second Amendment people simply don't know what's best for you. Here's what the Wall Street Journal writes. In the Maryland opinion, Judge Wilkinson second-guesses people who say they keep or bear an AR-15 style rifle for self-defense. Quote, compared to a handgun, the AR-15 is heavier, longer, harder to maneuver in tight quarters, less readily accessible in an emergency, and more difficult to operate with one hand, Judge Wilkinson writes. The rifle is powerful enough, Judge Wilkinson argues, that firing it at an assailant in close quarters will often put the safety of cohabitants and neighbors in jeopardy. So the Wall Street Journal is basically saying, look, the theory or argument by Judge Wilkinson is he's smarty and you're not. He knows what's best for you and you don't. So even if you think an AR-15 is good for self-defense, you're wrong, you moron. You don't know what you're talking about because you're not the 80-some-odd-year, 90-year-old Judge Wilkinson who used to be important in the federal system and no longer is. You need to shut up, usurp, and do what Judge Wilkinson says. That's the gist of that opinion by Snope versus Brown that the U.S. Supreme Court, in my opinion, needs to step up and fix and make these judges, including Judge Wilkinson and the rest of those federal judges that refuse to follow the law of Heller, which remains good law. Heller was cited favorably somewhere in the order of magnitude of 100 times in the 2022 decision by the U.S. Supreme Court in Bruin. So again, it's extremely good that the Wall Street Journal editorial board is making these points, essentially criticizing Judge Wilkinson for this holier-than-thou attitude toward American gun owners and the constitutional enumerated right, the Second Amendment's right to keep and bear arms. So in its summary, the Wall Street Journal editorial page basically says that on the one hand, you have Judge Wilkinson that says, you have to defer to the lawmakers. We have to defer to the judges. You have to defer to the people that know what they're doing. Don't defer to we the people. Defer to our elected betters. But the Wall Street Journal basically raises a question about whether or not this was right. This is the final observation they make in this editorial. The editorial board writes, quote, "But the Second Amendment is not an inkblot on the Constitution. It means something. Can that possibly not include a right to own the gun that claims to be America's best-selling rifle?" So there you have it, folks. Powerful language from the Wall Street Journal editorial pages. They did not overdo it. They don't need to. They really set the stage to say, hey, it's time to do something about this because, again, the only courts that get to weigh in on this particular issue of these types of arms bans are the courts that are based in these deep blue areas of the country. And the red state courts, the Texases of the world, the Louisianas of the world, the Floridas of the world, you see what I'm saying? These parts of America never get a chance to weigh in on an AR-15 semi-automatic rifle ban because there are no such bans that are enacted, which is a good thing. But the reality is when you look across the tapestry of American law, you're only seeing rulings against the Second Amendment, but you're only seeing them from the usual suspect states, those deep blue states that are full of judges that were blessed by deep blue senators, often by deep blue presidents. So that's exactly what you would expect to get, kind of a de facto rubber stamping of these anti-American, anti-gun laws by blue state judges in the blue states that are enacting these laws in the first place, and you never get a countervailing pushback by red state judges because the red state judges never get a chance to weigh in on these because they never have to deal with a gun ban that comes before them because there are no gun bans for them to decide the constitutional question of, which again is a good thing for all purposes except, of course, it doesn't create a circuit split. So to the extent the Supreme Court wants to wait for a circuit split on this issue, it's probably never going to happen. And they're not stupid. They're going to get this point, but hopefully they will understand why it will never happen and they step up and do the right thing. This will require some courage and fortitude and respect for the U.S. Constitution, and I'm optimistic that this Supreme Court will have the fortitude necessary to step up and defend our right to keep and bear arms. It is very important, in my opinion, that the U.S. Supreme Court ensure these lower inferior courts are following the law as they set forth, because if the Supreme Court will not police its own decisions, when lower courts go rogue, nobody else can, nobody else will. So they've got to do the job themselves. And I'm optimistic this court will have the fortitude and courage to step up and do the right thing, not just for you and for me as American citizens and right holders, but also for the institution of the Supreme Court itself. You do not want lower courts thumbing their noses at the Supreme Court. That is not good for the rule of law to have the Supreme Court disrespected by the lower courts. Only time will tell. We will see what happens over the next 4 weeks. We should know whether or not they're going to grant cert in the Snope case and hear this case on the merits sometime between now and the middle of January. And I, of course, will keep you informed as things progress. All right, folks, so there you have it. Hope you learned something here today about the Wall Street Journal and the editorial board over there. Make sure you follow me on X at 4boxofdonner. Make sure you vote for the 2025 Gun News Awards for 4boxofdonner for the top voices of 2A. Make sure you subscribe to this channel. We're trying to get to 200,000 subscribers as fast as we can and catch up to the rest of the Second Amendment community. And don't forget to share this video and to like it. By the way, I'm also now posting these these videos on Rumble. That's right, on Rumble. Brand new over there. So to those of you who want to check it out on Rumble, feel free to go over there. Even if you don't watch it on Rumble, it'd be nice to at least if you subscribed over there, because I think right now I have like 100 subscribers or something like that on Rumble. So, it'd be good to expand that number to some real number over there on Rumble. But again, I just started there like 3 days ago. All right, folks, hope you enjoyed today's show, and I look forward to seeing you again very, very soon here at the Four Boxes Diner.
Orders up. Table 2A.